we are on the record on September 28th, 2023, a jury convicted the defendant of one count of first-degree murder, but the jury also finding true the special allegation attached to that count pursuant to Penal Code Section 190.2815 in that committing murder while lying in wait. Additionally, the defendant was found guilty of one count of first-degree burglary. Let me ask, does counsel for the defendant wish to be heard?
As far as?
Anything, sentencing, any issue?
On sentencing, yes.
Yes, you may proceed.
Well, the prosecution has filed a sentencing memorandum asking the court to impose consecutive time for the burglary, which I believe is prohibited under 654.
And the court agrees with you.
Okay,
yeah.
That would be, thank you. I don't think the court has any discretion regarding...
Right, everything else is statutory pretty much. Yes.
Thank you.
Okay. Anything that the people wish to be heard?
Not as to that issue. We do have several victim impact statements.
Okay, as to that issue, that I think it's pretty clear, and I'll cite the case of People versus Williams at 157 Kellap 3rd at 145 regarding the same objective to be accomplished and the intent of the defendant at the time that he entered the residence there would be subject to 654. I understand you've added some more names. We have 10 impact statements.
There'll be 9 here in person, and then I'll read a 10th victim impact statement from victim and witness Michael Herman.
Okay, because of the number, we need to have those impact statements to be brief.
Yes.
Okay. Also, as an aside, there's a non-statutory motion to return property and objection.
I received that, I think, 2 days ago while I was in trial. I told counsel I have to review it with the investigators, and I will get back to them on that issue.
Okay, to the court, I got to tell you, unless I hear some compelling reason, the court is inclined to sign it, but I'll wait until I get some impact from people. All right, you may proceed.
Thank you, Your Honor. People call for the first victim impact statement, Tom Harwick.
Let me ask, does counsel for the defendant waive time for arraignment and judgment and sentencing?
The probation report?
Yes, do we have one?
We do not have one.
Okay.
I understand that the court can order one.
We will, and I think one has been ordered.
And we do not want Mr. Pursehouse interviewed for the probation report. And I will be submitting a defense statement pursuant to Penal Code Section 1203.01 to go to CDCR along with the probation report.
To be incorporated in that file?
Yes, Your Honor.
Okay, having said that, any legal cause why judgment should not be pronounced?
No, would the court like the time credits?
Yes, you can do that.
I believe there's 1,390 days of actual time served.
Okay.
That's calculated from February 15th, 2020 to today's date.
Okay, noted.
He was out on bail, but he was wearing an ankle bracelet. So I believe those days also should be included in the credits.
So the amount that you gave is the aggregate of all of that?
Correct.
Okay.
Your Honor,
yes?
As far as restitution, I have submitted documents for restitution to the Victims' Compensation Board in the amount of $7,500.
Got that?
And I have submitted documents to the defense for restitution to the victims' parents, Tom and Penny Harwick, in the amount, I believe it's about $25,000. There may be a dispute as to dates. We're hoping we can resolve that issue on a later date without I don't believe, I think counsel will waive the presence of her attorney for that purpose.
I believe Mr. Pursehouse will waive his presence.
Do you want me to order it today, and then if it needs to be tweaked or modified, the court will do so at that time?
I think we'd like to just have the amount determined at a later date.
Okay, I can certainly order the Victims' Compensation Board amount.
Right, that I don't think there's a dispute.
Right, but there remains the $25,103.95.
Right.
All right, for lodging and travel and parking and meals and so forth.
Right. I think counsel wants to dispute some of that amount, so we could do that at a later date. The $7,500 for the Victims' Compensation Board, I don't believe there's any dispute as to that amount.
So do you want me to set a date in the future, or do you want to notify my clerk when you've reached an agreement and then calendar it at that point?
I think the court's going to need to make the determination.
Right, but do you want me to, once you've reached that, the court can then set it, and then you can advise the court as to what you've reached?
We won't be able to agree.
Okay,
I'm going to ask for the full amount of the $25,000.
Oh, I thought you guys were going to try to work it out. I misunderstood.
No,
Okay.
it's a dispute as to when the trial started, or should the reimbursement go all the way to August 8th?
Okay, so I take it that you will be submitting to this court something that will outline all of those days.
Yes,
Okay, and the court will ultimately decide that.
yes.
Okay. That having been said, the defendant is presumptively ineligible for probation, absent a special finding that this was an unusual case where the interest of justice would be served if probation were granted pursuant to Penal Code Section 1203, subsection E1. In view of the nature and the underlying charges, as well as the conduct engaged in by the defendant, this court is not inclined to impose a probationary sentence and/or make a finding that the imposition of a probationary sentence would be in the interest of judgment. Accordingly, it is a judgment and sentence of this court that the defendant shall be sentenced to a term of life without the possibility of parole with respect to count 1 for the underlying murder charge, coupled with the special circumstance allegation alleged under Penal Code Section 190.2A15. As to count 2, the first-degree murder, the defendant shall serve the midterm of 4 years. However, the term shall be stayed pursuant to Penal Code Section 654. Did I say first-degree murder? I meant the count 2 first-degree burglary. I misspoke. But that shall be stayed pursuant to 654. Thus, the defendant shall receive a total sentencing term of life without the possibility of parole, and with the 4-year midterm with respect to the burglary charge to be stayed per Penal Code Section 654. Defendant is to make restitution to the Victims' Compensation Board in the amount of $7,500 for burial costs. I understand that the parents have incurred additional cost in that nature. Is that correct?
Yes.
Defendant is to provide all appropriate DNA samples as dictated under Penal Code Section 296. Pay a restitution fine of $300. The court will stay the parole revocation fine of $300. He's to pay a court security fee of $40, a criminal convictions assessment fee of $30. He's also prohibited from owning, purchasing, receiving, possessing, or having under his custody or control any firearms, ammunition, and ammunition feeding devices, including but not limited to magazines, and you are also to relinquish all firearms in the manner provided under Penal Code Section 29810. Mr. Pursehouse, it is my duty at this time to advise you of your appellate rights. You have the right, absolute right, to appeal from the judgment of this court and imposing sentence on you today. That means that if you wish to appeal, you must file your written notice of your intention to appeal within 60 days from today. An appeal not filed within 60 days shall be void and of no effect. The notice must be in writing and signed by you or your attorney or both of you. It must specify what you are appealing from, whether it is the whole judgment or just part of the judgment. If you appeal and do not have the financial ability to retain the services of an attorney to represent you on appeal, the appellate authorities will appoint counsel to represent you. In that regard, it is your obligation to keep the appellate authorities advised at all times of your current residing address so that they can be in touch with you to advise you of your appointed counsel. I'm going to set a future date with respect to the restitution aspect going to the parents. I expect that you will have some kind of itemization regarding the days of lodging, the days of travel, the days of meals, and so forth. So I would expect that. How much time do you need? Going into January, obviously.
Right. I need to get some more receipts from them regarding maybe meals and other expenses they had that they did not include at the beginning. So I just need about. Can we do this in January?
Yeah, this guy has to go in January. We're dark starting the 16th.
So whatever's
15th is the last day.
Whatever's convenient for counsel in January.
Let's see. What about January 31st? Is that a good day? That's a Wednesday.
That's fine.
Okay.
That's fine with me.
So that'll be set for 8:30. In the meantime, prior to that date, submit an itemization,
Yes.
if you will, and then I'll set it for restitution at 8:30. All right?
Thank you.
All right. That'll be the order. Thank you.
Can the audience remain seated until the defendant's out of the courtroom?
All right, we stand in recess.
Thank you.
Yes.
Thank you very much.
You